Does forced conscription into the IRGC put your chances of immigrating to Canada at risk? Since Canada listed the IRGC as a terrorist organization, thousands of Iranians who were forced to serve are now facing unclear rules, rejected visa applications, and denied permanent residency. Conservative member of the Parliament, Garnett Genuis, who first brought the IRGC motion to the Parliament, says the Liberal government ignored the protections for conscripts, leaving them exposed until the law is fixed. Mr. Garnett Genuis, member of the Conservative Party of the Parliament, thank you for your time today. Given your long advocacy since 2018 for listing the IRGC as a terrorist entity, the government delayed the decision for years, partly because they claimed they wanted to protect conscripts. Now, the same conscripts appear to be the ones most affected, while Iranian officials still managed to come to Canada. What is your take on this?
Yeah, look, the Liberal follow-through on this has not been effective. I mean, obviously, they had to be dragged kicking and screaming to this position. They opposed it for a long time. They eventually did the listing, but we continue to have concerns about their effectiveness at addressing foreign interference across the board, their failures to implement foreign interference legislation that they passed. In terms of the impact on conscripts, I put forward legislation to list the IRGC as a terrorist organization before that listing had happened. It was Bill C-350 in the last Parliament. And that had a section specifically designed to provide this protection for conscripts. It was an amendment to the Immigration and Refugee Protection Act that said that an individual would not be deemed to have been a member of a listed organization if it is established that person met certain specific criteria, that they were required to fulfill a period of mandatory service with that organization, that they did not remain with the organization for a period longer than the mandatory service period, and they did not engage in any terrorist acts or atrocities themselves when they were part of the organization. So if those three criteria were met, my bill would have protected people in that situation. We shouldn't be punishing victims of forced conscription. We should rather be targeting those that voluntarily joined or stayed with terrorist organizations, and of course those that were involved in committing atrocities themselves. So, ironically, we provided the Liberals with the solution to an objection that they had, but then after listing, they failed to implement our suggestions on how to do it well, how to do it right, how to do it effectively.
In one of the court rulings I reviewed, forced conscription was interpreted as a situation where a person's life or health would be endangered if they refuse to accept the conscription to the IRGC. But in Iran, a 19-year-old conscript cannot opt out, and they don't even know the future of their immigration plans. In that context, should forced be interpreted differently?
Yeah, so I'll go back to the legislation that I had put forward, Bill C-350, in the last Parliament, that I think addresses this concern. It doesn't actually use the language of force; it uses the language of required. So what the section says is that again, it would not the prohibitions on the entry to Canada of someone that had been a member of a terrorist organization would not apply in cases where certain criteria were met. One of those criteria was required to fulfill a mandatory service period with the organization. So if the person chose to join that organization, then we'd have a problem. But if they were required to join, that would be a different circumstance. It doesn't prescribe exactly, what does it mean to be required, what would be the response if you didn't. But I think a common sense interpretation of that would be that if the law said that you had to do that, regardless of what the punishment was, if the law said you had to do something, that would be understood as a requirement. And again, the criteria is very specific that we put in C350. Required mandatory service period, did not continue with the organization longer than that mandatory service period, and did not engage in terrorist acts while part of the organization.
You mentioned Bill C-350. What is the current situation of that bill?
Well, this was a bill that I tabled in the last Parliament, and the centerpiece of it was listing the IRGC as a terrorist organization. So that action has happened, but there are other parts of the bill that could be taken up. The amendment to the IRPA on forced conscription. And by the way, this section on forced conscription, it doesn't just deal with the IRGC. It's a general amendment that would apply to any instance where an individual was compelled to serve in the ranks of a terrorist organization. You can imagine many other cases of this happening, where a terrorist organization takes captives, forces people to be in the military of that organization. We have a situation, sadly, in Afghanistan where the Taliban is the de facto authority. So there are many cases, I suspect, where we would see other forms of forced conscription into listed terrorist organizations. And so I think this is a good amendment. But if this bill was to be put forward in this Parliament, it would have to be changed somewhat because the previous version, the centerpiece of it, was listing the IRGC, and that's already happened.
Have you been contacted by Iranian individuals affected by these new admissibility decisions? Have they asked you to revive or amend Bill C-350?
Well, I mean, I've had ongoing conversations with members of the community on this and other issues. I know that this issue is a concern. We are still relatively early in the life of this Parliament, and private members' bills are fairly limited in terms of the opportunities we have to bring them forward. It's a very long and difficult process to pass a private member's bill. So this I think continues to be a good idea that we put forward. The simplest thing would be if the government could incorporate this provision into a government bill. Generally speaking, government bills pass far faster. Most private members' bills don't even have an opportunity to bring a bill forward to debate and a vote. So this is a provision that I think is very valuable. It could come up in a private member's bill again, although we have limited windows in which to do that. I think the best course of action would be that the government listens to the solution we put forward and implements our solution.
Based on the current situation and the recent rulings, do you think rejecting permanent residency for a refugee who has lived in Canada since 2019 violates a person's right?
Well, I would have to know all the specifics of a case, but I would stand by the proposal that we put forward, which was to say that a person who is a victim of forced conscription is in a very different situation from a person who voluntarily joins a terrorist organization. We should not treat those people the same. We should not apply the same requirements. That a person who was forced into a terrorist organization, did the minimum they could while they were there, and didn't commit atrocities while they were there, that person should not be considered to have been part of that organization for the purposes of our immigration rules. And this is why we put forward changes to propose that happen. The government went forward with listing, which it's good that they finally did that, but they did not do it in the way we recommend. The way we recommended would have addressed the issue.
IRCC told me that being conscripted does not automatically mean rejection. But according to their email, which was very vague, would it be fair to interpret that someone who was rejected their permanent residency was more involved with the IRGC than just a regular conscript?
Well, I mean, I can't comment at all on the specific case. I don't know. But the vagueness is a problem, and the reason we put forward this legislative change was to address the fact that there isn't clarity at all right now around how a decision would be made in that regard, or how a person's membership would be assessed in a case where that membership was not voluntary. Our proposal sets out clear criteria so that we are excluding the bad guys and not lumping lumping conscripts into that same category. So I think the conservative position provided substance and clarity, and we're not seeing that from the government.
Is it fair to say because the law is vague, different officers may apply their own interpretation, leading to inconsistent decisions?
Well, it sounds like in the absence of clarity in the law, there's a risk of discretion pointing in wildly inconsistent directions. Of course, the way I read the present law is that a person is inadmissible to Canada if they're part of an organization with no clarity or protection provided for those that are compelled to be part of an organization. So again, the changes we put forward in C-350 would have provided the clarity, and in the absence of that, I think there is a risk of uncertainty, the wildly differing application of discretion, and other kinds of problems.
With as many as 15,000 people potentially affected by these rules, was it still the right decision to list the IRGC as a terrorist organization, given the unintended impact on conscripts?
Well, I definitely think the IRGC needed to be listed as a terrorist organization. It needs to remain listed as a terrorist organization. But it's not a choice between doing it in the wrong way and not doing it at all. We suggested doing it in the right way, and we provided a clear path for doing that. So, yes, the IRGC needs to be on the list, but we provided the path for the government to do it right and to protect people that had been victims of forced conscription.
Minister Anita Anand recently said Canada has no intention of re-engaging diplomatically with Iran. At this point, is that even a choice?
Well, look, we continue to think that the core reasons why during the Harper years Canada ended diplomatic relations remain very much relevant today. The threats to peace and security in the region, the human rights abuses, the threats to the people of Iran, and also concerns about foreign interference by the regime, and the way that the regime weaponizes the presence of foreign diplomats in their country and in ways that are often dangerous for those diplomats. All of these remain issues. Now, the Liberals have been wildly inconsistent on this. They have really gone back and forth in their position on it. And we have seen, I think, a de-emphasizing of human rights and a de-emphasizing of the fight against foreign interference under the Carney government. I think many of the steps he's taken in that regard have been in the wrong direction. So we'll see. We'll see what they do. Our position remains the same, and I think has been shown to be the right position. The Liberals are kind of leaning again into this more appeasement-oriented foreign policy. We'll see. So we'll see where they end up, and we'll keep holding them accountable for their direction.
You mentioned transnational repression. Do you believe that the Canadian government is taking transnational repression by the IRGC seriously enough?
I still don't think we're seeing enough response to that. There are many different concerns from many different communities. The government passed Bill C-70 in the last Parliament, and we collaborated with them to strengthen that bill and to pass it as quickly as possible. But there are still significant gaps in implementation. So the first and most obvious step they could take on combating transnational repression would be to implement the legislation that they themselves proposed.
And for my last question, for many people affected by the conscription issue who are now dealing with the uncertainty, what is your suggestion for how they can clarify the situation?
We have put forward a policy on it that I think provides a solution. And my suggestion would be that people have a look at that language in Bill C-350 from the last Parliament, and contact their Liberal MPs if they're in a Liberal riding, or their members of Parliament in any event, or government ministers in the area, and say, look, Conservatives put forward the solution. Why haven't you implemented the solution that they've already put on the table?
Mr. Garnett Genuis, thank you for your time.
Thank you.